gives us the opportunity for more prosecutions, I would say, because there's more flexibility in it. It's easier to prove. You have to prove that there's been either threatening, abusive or insulting words or behaviour, whereas for religious and sexual orientation it's limited to threatening behaviour. So it's a completely different threshold, much harder to prove, and the issue about threatening is the issue that's been considered in the original trial of Bamber under religious hatred, and also the trial that's coming up for sexual orientation. The other issue that's very prominent and causes difficulties is that under the racial hatred banner, you can prosecute for an offender who's got either the specific intent, so you can prove that they intended to stir up racial hatred, or what we say, likely in all the circumstances, that they stirred up hatred. So that means that you can take into account the context of the behaviour, what other people, what other witnesses have said about it, what's shown on CCTV, any background information to the offence, and any ideological material you may have. Unfortunately, that second clause, the lower limb, which is easier to prove, isn't available to us for religious or sexual orientation, and again causes significant problems. We can only prosecute if we can prove that specific intent. And as various people have discussed today, obviously, in effect, proving a thought crime is very difficult. The only way that we can really prove a specific intent is by finding ideological material that supports and corroborates perhaps that person's offending behaviour. I think a couple of people have mentioned today that most people don't admit that their behaviour is motivated by any sort of bigotry. We've been fairly fortunate, I would say, in a number of the prosecutions that we've had for racial hatred to find ideological material from whether or not it's the far right or extremist Islamics. There's a lot of material that's been found. There's things like tattoos, evidence of membership of certain organisations and the views and activities they prescribe to, as well as documentation, ideological material, videos and that sort of thing's been located. Obviously that doesn't prove the specific intent, but it goes some way to corroborate what we would say and what presumably the victim is saying was the motivation. As I've said, we've had the one prosecution for religious hatred in the UK, which is a case called Bamber, which was tried last summer. We don't know why the jury found him not guilty. We can only make assumptions about that. But the feeling is, from the nature of the defence that was run, questions that were asked of the jury during their deliberations, was that they didn't find the leaflets threatening, and also they didn't find that specific intent. But both that case, Bamber, and the current prosecution for sexual orientation, which is probably going to stand trial later in the summer, were to do with leaflets. They're very similar in the facts, in that leaflets have been distributed around the local communities. One that was inciting religious hatred, and the other, we say, was inciting hatred against sexual orientation. In respect of both cases, there was a number of leaflets, all of which were offensive and insulting, and members of the community were appalled and disgusted by. Many members of communities who received these leaflets made complaints to the police, but there was, in respect of each case, only one leaflet that we say met the test and passed the threatening behaviour test. And both of those were leaflets that in effect incited murder. We said both of them have depicted pictures of people being murdered in principle, and been quite clearly motivated by the racist or sexual orientation angle. And as I've said, we can only presume what the jury were thinking when they made that decision in Bamber. One of the issues that we consider in prosecutions is the term hatred, and there's been a lot of discussion about that today, so I'm not going to say much about it. All I'd say is that we say, and in most opening speeches in court, would say it's a strong emotion, it's far more than dislike or hostility. That's simply not enough. So it has to be a really high threshold to meet. One of the other issues that we encounter that causes problems for us in the UK, and again has been touched on marginally this morning, is the angle of human rights, the freedom of expression, freedom of religion, and also freedom to protest in our country. One of the things that we have to consider when we're looking at incitement to any of these offences is the balance of a democratic society, the right to free debate, to be able to discuss ideological, political, religious issues without fear of prosecution. That obviously is allowed. It's the extreme offending behaviour that is not. And I'm hoping to demonstrate with some cases that we've prosecuted what we say the line is, so you can kind of understand what we would prosecute and what we won't with actual case demonstrations. And I'll come to that in a moment. Paul's just briefly mentioned the issue of international assistance in the case of Shepherd and Whittle. In a lot of our cases, we need mutual legal assistance from other countries to assist in prosecuting, and that's more so in light of the age of the internet, Facebook, YouTube, things like that. As Paul says, they're at the moment probably the biggest tools for inciting hatred of whatever form. They're an open forum, totally anonymous if you wish so, and one of the things that we have to get around is the if you want to be totally anonymous, you don't need to put your photographs, you don't need to use your real name. You can do that all under pseudonyms. And the only way for us to track back who the actual offender is to go to the country who owns the host sites and get the information from them. On the whole, that tends to be America, and we have real problems with America and reciprocal arrangements for mutual legal assistance in this field. As you've heard, the USA have the First Amendment, which is far more liberal than our human rights, freedom of expression clauses and things like that. And they have no direct reciprocal legislation for our incitement laws, which is a big downfall. The only offences that we've managed to get mutual legal assistance from them is where we've also been prosecuting for things like soliciting murder or offences under the terrorism legislation. So at levels of offending that are much higher than incitement alone. And effectively through the back door we've managed to get the assistance that we require. Obviously one of the issues for us going forward, and it is something that the Americans are looking at, is this issue about the internet and their host sites and servers. And the case of Shepherd and Whittle is really a prime example of how this worked badly, but the UK managed to get around. I don't know if many of you know about the case of Shepherd and Whittle, but it was two gentlemen prosecuted. It took quite a few years for them to be prosecuted due to various stages of appeals. But it was inciting racial and religious hatred, and it was basically anti-Semitism. They had a number of documents in their physical possession, but the prime thing that they'd been doing, and the link with America, was the fact that they'd been setting up websites in America, but obviously carrying out all the work in the UK. The websites were all amalgamated in the UK. Everything that they posted onto these websites was formed in the UK. There was a number of documents called things like the Holler Hoax, and they were uploaded in the UK onto websites that had been set up in America. What they argued was that the UK had no international jurisdiction to try these offences. This is just one of many arguments, but they said that the actual act, the uploading and people looking at the internet was taking place in America because the website was based in America, not in the UK. And therefore, if they were to be prosecuted, it should have been in the US, where there was no law for prosecuting this. Fortunately, the judges in the UK at the Court of actually it might have been at the House of Lords, but there was various different appeals in this. Fortunately, our judges said all of this activity took place in the UK. Simply clicking a button and it then appearing on an American site doesn't mean that the offence took place in America. It took place in the UK. Therefore, we've got jurisdiction to try it. It goes to the jury and they convict it. The other aspect from Shepherd and Whittle to do with the US was that because of this argument, they also, once they were convicted, they were on bail and they absconded and went to the US and sought political asylum. And so again, that was a huge issue. They sought political asylum and saying they were being persecuted for their religious beliefs. And they were put in custody in effect pending that appeal in America, but ultimately they came back off their own volition. But it's obviously a case that illustrates the huge difficulties we've had with America in relation to these issues. And it is something that the Americans are considering at the moment. I think it's one of these things that's going to take a long time. It will require a lot of international support and assistance and guidance with them, but you know, it's something that they are now actively considering. Right, I'm just going to turn now to some of our cases, real cases that we've prosecuted in my division over the last few years, which will hopefully illustrate to you where we, the prosecutors who are looking at these, draw the line and how we recognise where the law is drawn between freedom of expression and actually committing an offence of incitement. The first case I'll refer to, and I'm sure you've all heard of, is Abu Hamza. He was prosecuted for solicitation to murder as well as incitement to racial hatred, possessing threatening recordings and possessing a document that was useful to a terrorist. All of those speeches were recorded, and the contents of his speeches were made at public meetings. They were recorded onto tapes, and we said that they all demonstrated violent hostility to certain classes of people, and there are various different classes of people referred to within his speeches. One of the prime videos recorded speeches advocating the killing of those who do not believe in the Islamic faith. He emphasised the importance in those speeches of fighting and identified on them those who he deemed legitimate targets. He stated that there was no drop of liquid loved by Allah more than the liquid of blood in the cause of Allah. Whether this is achieved by a Serb, a Jew or any enemy of Allah, he emphasises the importance of using the sword in the cause, so clearly soliciting murder as well as inciting hatred. He also, in another speech, advocated the killing of non-believers, stating that it was acceptable to kill a non-believer even without any justification or reason, just because they don't believe in the Islamic faith. He was prosecuted and convicted quite a few years ago now, and the judge in that case emphasised that it's not an offence to describe Britain as a toilet, nor is it an offence to suggest that the West is corrupt and without moral conscience. He went on to say it is, however, an offence to say that the killing of non-Muslims is justified in any circumstances. So I think that's quite a clear example of what we would prosecute. Another case that's not that dissimilar is the one of Abdullah al-Faisal, who again was another cleric, Islamic cleric, who in his sermons solicited others to murder. Again, like Abu Hamza, he had a vast audience in mosques around London. Again, the sermons were recorded onto audio tapes, and they've been distributed all around the country and to other countries and being listened to as well as his actual sermons. From those quantity of tapes, and there were hundreds in relation to him, the police seized upon 8 of the most graphic and offensive tapes and used them as the basis of the prosecution. An example of one of the things he said is there any peace treaty between us and Hindus and Indians? No, so you can go to India, and if you see a Hindu walking down the road, you're allowed to kill him and take his money. He then went on, it is incumbent upon us Muslims to remind the believers of the importance of killing these disbelievers, finding them and killing them, and to remind the believers that they are our greatest enemies. So again, completely disparate, no direct reason other than the fact that they're just, in their eyes, non-believers. Finally, another example of that type of offending behaviour is what was deemed the Danish cartoon protesters. You'll probably recall back in 2006, a Danish artist published in the newspaper, and then it was reprinted, a picture of the Prophet Muhammad with a bomb in his turban, which caused great offence. In light of that, in the UK, a number of people went and protested in Parliament Square and outside the Danish embassy. And during the course of those protests, both on banners and placards and verbally, they were calling for France, Denmark, the USA and London to be bombed. And again, they were calling for the Danish cartoon protester to be killed. They were convicted, again, of inciting religious hatred and also soliciting murder. And they received between 4 and 6 years imprisonment for those offences. So they're one kind of example of offences of inciting hatred. There's a second example, which is offences that go quite as far as soliciting murder, but are calling for violence, immediate violence and immediate unlawful behaviour. One of the cases Paul's already mentioned, so I won't go into detail, was the case of Neil Martin and the Anthony Walker tribute site, which he in effect defaced with very abusive and offensive language. And the other case I'll mention briefly is the one of Stephen Dempsey. He circulated numerous disturbing and racist notes to members of the public in his local town. In one, he described how he and his group would love to slice open the stomach of heavily pregnant white women before stamping on the fetus. And the other leaflets were very similar, and they were showing extreme prejudice against Black, Jewish and Chinese people, and effectively against mixed race babies. So that was what that was about. Finally, in relation to where we draw the line, I'll just mention a couple of cases which we've not prosecuted, which have been very high profile in the media, and I hope you'll agree that we didn't prosecute them for the right reasons. The first case was one that was referred to us related to Anne Robinson, who was on a television show, and she told Paul Merton that she hated all the Welsh and wanted them put into room 101. Numerous complaints were made to the police, who of course referred it to us to have a look at, and we effectively said, no, you've not met the threshold, the Welsh can deal with that, they're robust enough, I'm Welsh, I can sit here and say that. It's not an offence, take it on the chin. The other one that's even more absurd was actually charged by Thames Valley Police, and during the course of a protest, a mounted policeman arrested a student in Oxford because the student told the policeman that his horse was gay. So he was actually charged, and we discontinued that and said it didn't amount to an offence, get on with it. And you know, it clearly would have been farcical to try and take that to court. So there's some of the cases that hopefully demonstrate to you where we think the line is drawn. I'm just going to finally mention one other issue that we routinely deal with and have at the back of our mind when we're looking at cases. And again, it's something that's been touched upon a few times, but it's engagement with the community. And I think Nadine's going to be talking a little bit about that as well on the CPS. You've heard today that we have hate crime scrutiny panels. We also have what we call community involvement panels, which are a bit different. My division, which is the Central Headquarters Division for Prosecuting Incitement, have a number of community involvement panels set up for different things. But in respect of incitement to hatred, we meet very regularly with different community groups. We meet with Stonewall from the gay, lesbian, transsexual think tank arena. We meet with the Jewish Community Security Trust, Islamic, Christian, Sikh, all sorts of different denominations from the religious orders to discuss what we're doing in relation to cases that affect their communities. We'll speak to them about specific cases that we're looking at and basically listen to them about how things are affecting their communities. It's also for us a good way to try and get evidence and information about the impact that a hate crime has had on a particular community, and if there's anything particular that the community wants fed back into the court, then that's something we'll consider with them. So if there's any questions, I know it's a bit of a quick rattle through, but running out of time, so any questions about anything? Yeah.
Well, just again to the level of tolerance. You gave some examples for that line, and I understand that the British law system is more made on cases than on written definitions.
Yeah.
But for me as a psychologist, and I think also for the workshop, of course it would be helpful if you could give us some outline of your internal representation of that line.
Yeah, it's very difficult. Yeah, we don't have set down in statute any definitions. The case of Bamba is a good case example of where we spent a long time considering whether or not these leaflets amounted to threatening or not. we said it was an implicit threat rather than an explicit threat, and the whole court hearing was really in essence about this issue of what is threatening. Unfortunately, because it was a first instance decision, there's no transcripts publicly available. But the whole essence of that court hearing, which went on for I think about a month, was discussing what is threatening, looking at different examples, and that's all we can do really, because these issues, they're not set down in statute. We've got some cases to rely upon as precedent, but not many really to do with those issues. Most of the precedent cases in respect of this field are more to do with whether or not people like Sikhs or Jews amount to a race and religion, rather than the actual context of the sort of actus reus parts of the offences. So it is difficult. What was said earlier, a lot of what we rely on goes back to looking at things like dictionary definitions, as well as the parliamentary debates that took place when the law was coming through, and any other debates that have gone on surrounding them, what Parliament's intentions were when they brought the legislation in. But in essence, it's a sort of trite and see, and obviously in that case the jury weren't with us on it. Yeah.
Would you agree that our incitement to racial hatred provisions in the UK can be more accurately characterised as speech crime laws rather than hate crime laws?
Do you mean religious or racial?
Both.
Both.
And just to follow up on that, is there a blurring there? Because think about the Anne Robinson case. If she would have said that to me as an individual in this room, would it have fallen foul of our provisions for intentional harassment? Which again, are they bordering on speech crime provisions?
I think you're right in the first, not so much the race, but the religious hatred, particularly it's got a specific clause in excluding freedom of, I think it's J, excluding all sorts of things which in effect incorporates for the first time into an actual statute the freedom of expression element of legislation. And I think you're right, it's very, very difficult for us to prosecute, hence there being only one in 3 years. In fact, we've reviewed about 12 files for incitement to religious hatred. There's been the one prosecution which has been unsuccessful. Of the 12 files we've reviewed, some other charges have followed in respect of them, but not inciting religious hatred. I think a couple have been charged with soliciting murder, and others have been referred back to local areas to prosecute as low-level Public Order Act offences with an aggravated element. But the hurdles are so high to prosecute, and it is really getting over the speech, the inference of what people mean, the connotations put onto speeches, because a lot of what we're prosecuting are people's speeches, and if you don't have a full recording of them, you can't get the full context. People say, oh, I was only joking, I was just being sarcastic, I didn't mean it, that kind of thing. So it is almost a prosecution of speech crime.
Let's see, I have a couple of questions. Most of them connecting back to what you said at the beginning about this type of crime, and that the sort of threshold that you have to show is pretty high set.
Yeah.
So that's a different, and is this because this is a type of crime in itself, as in contrast to the case where it sends factors that you can use to motivate an enhanced sentence?
I think the media and parliamentary debates when the Religious Hatred Act went through form the answer to part of the question. A lot of people in the sort of theatrical and comic arenas were loath for it to come in because they thought they'd stand up and tell a joke and be prosecuted, which never was the intention of Parliament. But there was a lot of lobbying from that kind of field, which explains why perhaps, it explains completely why it's been limited back to threatening rather than abusive and insulting. And also why the freedom of expression clause came into it as it is, which is quite lengthy and specifically prohibits prosecutions on the basis of
Okay,
those
so
type of
so it
things.
has to be trade-off with
Um,
freedom of speech, I guess.
Yeah, and I think in terms of the rate, and this is just my thoughts, but the difference between the racial hatred law, where we've got the likely and all the circumstances fallback, so you can look at the context of what someone's doing rather than just what they actually specifically intended, is that obviously race hate is something that people on the whole, I won't say totally because there are a few comics have made jokes about, very inappropriate jokes, but I think it's much more widely accepted that it's intolerable. Certainly in the UK, and I think that goes some way to explain it.
Yeah. Okay, so my follow-up question on this comes up with what you say in the end, that at the end of the day, you're actually prosecuting quite a few cases. And
Yeah.
this is because the difficulties involved in proving these two things, I guess.
Yeah. The racial hatred, we prosecute a fair few. I would say most of the cases that are referred to us for inciting racial hatred probably about 70% of those result in a prosecution, whereas the ones, religious hatred that get referred, they just simply don't meet the threshold. It's very difficult to get the evidence to prove those elements. Yeah.
Okay. So in the case of racial hatred, then, do you have to sort of demonstrate that the context was such that it was likely that what this person said or wrote or whatever would influence other people to commit,
To stir up hatred.
things?
Yeah, we can do what we would normally do with the race hate. You've got the two limbs, specific intent or likely in all the circumstances that hatred stirred up.
Yeah.
Proving a specific intent is very difficult. Most offences we just prosecute it under the second limb. Where it's more explicit and perhaps someone has made omissions, we'll do it under both, and the jury can make they don't have to say actually, but we can leave it so the jury can either find the specific intent or that is likely in all the circumstances. And likely in all the circumstances, obviously if there's a fight and there's dozens of people watching a fight and racial abuse is given out or the context is that, you can get witness statements from those people which infer the context. If they all say he was making racist remarks and we deemed it to be racist, then obviously the jury hopefully going to find that the case.
I have one more question, and I have to admit that I can hardly put it in the right words because I don't know your legal system so exactly. Some weeks ago, Mark sent something around that was on antisocial behavior.
Right.
That was the first time I saw that kind of legislation or procedure, legal procedure. It was not on laws, but how you can work with people who are going around and littering things and vandalizing things and things like that.
Antisocial behaviour orders, yeah.
Sorry, I was quite impressed by it because, as far as I understood it, it's something I would call a low-level approach to prevent escalation
Yeah.
of things that are not really a crime, but on the way to becoming a crime. Is something like that also possible with hate crime?
They can be considered. It's what we usually call an ancillary order, so that you can get. The police can apply for civil antisocial behaviour orders where there's insufficient evidence to prosecute someone, but that's quite rare. They're usually an ancillary order on conviction. The prime example is youths who, causing terrible problems on their housing estates. You could get antisocial behaviour orders on them so that they're not allowed out after 6 p.m. They can't go to certain places, that kind of thing. And then if they breach them, I think it's 5 years of imprisonment is the maximum penalty. So it is a way in which you can deal with things. We certainly could, on the back of a conviction for inciting racial hatred, if it was appropriate, we could look at applying for an antisocial behaviour order. It is something that we could look at. We've never done it for an inciting religious or racial hatred simply because it's not met the circumstances. people have gone into prison. But people like Abu Hamza, if he hadn't gone into prison and been looking at extradition to the States, that kind of thing, he's a prime example of someone who we might seek an ASBO, so he's not allowed to preach in mosques, that kind of thing any longer. The other issue is looking at conditions that are actually enforceable, because some things are just not possible to really enforce, so it's being realistic about it, but it's a possibility.
Maybe that would solve it to a certain degree, this diagnostic problem you mentioned before. Looking for people who are on the way to do hate crime, so to say. It's beginning with more weak signs of hate or political motivation or gratuitous or something like that. Let's say somebody is going around and saying nigger to someone on the street and going on without doing anything.
It comes back to human rights, doesn't it? No punishment without having a crime committed. So yeah, it is, you know, those sort of issues are considered quite frequently in the UK, but it's something that's not very enforceable, really.
Yeah, I think the anti-social behaviour, although it's both strength and a weakness of the UK legal position. It can sometimes be seen from an external perspective as very easy for somebody to give an ASBO, and then those things aren't followed up on, it's seen as sweeping under the carpet. But if managed correctly, obviously it's a strength, but it's how they're both administered and managed that creates kind of the public disdain to ASBOs. Yeah,
and I think particularly when it first came into use, they were given to so many youths for low-level crime, and it was seen as a badge, wasn't it? Badge of honour, and totally counterproductive. But there are some areas in which it has worked, but on the whole, yeah, it's probably not necessarily used in the most pragmatic manner.
Any more questions? We'll have a short coffee break